right on track with the syllabus. We are exactly where we are supposed to be, which is dealing with performance in partial and total breach. And this follows nicely on from the chapter that we just studied about substantial performance or material breach, because we actually take a two-step analysis when talking about breach. We start with 241. By now you are very familiar with section 241 since you have seen it on 4 separate occasions. And now we're going to see it again and then roll it into section 242 because we're going to determine if we have a material breach, has it become total? And we're also going to talk about the implications. So I'll lecture for a bit. We have 2 cases to cover and then we'll break. And when we come back, I believe we go on to repudiation next. Now, whenever there is breach, there are damages. Breach leads to damages, or breach are the equivalent of damages. What I mean by that is if there is anything less than complete performance, if a contract is not fully performed, the party who has not fully performed is in breach to a certain extent. Right? And so therefore there are some damages. You were expected to perform at this level, you're expected to perform at an 8, you performed a 7, the damages are 1. You're expected to perform at a 9, you performed at a 7, the damages are 2. Right? I'm using abstract terms. We'll cover damages in detail in our last module for the semester, but anytime there's breach, there is damages. The question, however, is, does the breach result in the other party needing to perform? That's the fundamental question, because you may have breached and in that way relieved your counterparty of their obligation to perform, or your breach may be not so material, in which case the other party has to perform, and if they fail to perform, they are in breach. So lesson here, there can be breach on both sides. Both the owner and the subcontractor can be in breach at the same time for different reasons. And so we have to analyze whether or not canceling a contract or refusing to pay on a contract is appropriate given the level of breach by one party, or whether a repudiation of a contract is wrongful, whether the cancellation of a contract is wrongful, in which case there is both a breach and another breach. And so that's the upshot for today's lesson. So what happens upon a breach? Upon a breach, a party must pay damages. Right? Breach equals damages for any injury caused by the breach. Now, if the breach turns out not to cause any injury, we have something called nominal damages, $1, usually. Some token that says, yes, you breached, but no, it's not a problem. Yes, you breached, but no, it's not a problem. But if there are injuries from the breach, it is a problem, and courts will award often money damages. We'll talk about that in Module 3 in Chapter 9. And in addition, the injured party, under certain circumstances, may withhold performance. Right? You were supposed to do something for me. You didn't do it. You're in breach. Can I sue you? Yes, I can. Do I have to perform? Do I have to pay you? Or do I have to meet my obligation to the promise I made back to you? I do not have to do that if your breach was material, but not if you substantially performed. And can I cancel the contract, get someone else to do the job? That depends on whether or not the breach was total or not. So what do we do upon material breach? Upon material breach, by the way, I like that transition. I don't even know where that came from. I should do more of these, right? Upon material breach, a party may withhold performance until the breaching party substantially performs, and that's a period of time called the cure period. Just because you're in breach does not mean you are in the doghouse forever, does not mean you get locked up and we throw away the key. No, you have an opportunity to make good on the breach. And so while you were in the state of partial breach, there is a period called the cure period. And when that cure period expires, you are now in total breach. Total breach is irredeemable. And at that point, the contract may be canceled, but the breaching party has a right to cure for a reasonable time. For a reasonable time. What is a reasonable time? Of course, it depends on the facts and the circumstances, as that is the meaning of reasonable in contract law. And usually we're looking at what an objectively reasonable person would say or do in this consequence, in this situation. So we look at cure time in terms of what is reasonable. Now, if the breach is not cured during the cure period, if the breach is not cured during a reasonable period, you are now in total breach. Right now we are at the far end of our spectrum, right? What was our spectrum? We begin with complete performance, then we move to substantial performance. Material breach, and finally, total breach. At total breach, you have new rights as the person who's been harmed by a total breach. You may now cancel the contract, get someone else to do the job. You no longer have to wait and see if they are going to cure that breach. Once you are in total breach, it is irredeemable. It can never be cured. So, what is total breach? What factors constitute total breach? That is the name of the game for class today. What is the restatement section that tells us the factors for total breach? Section 242. So we go right from 241 to 242. We have 5 factors in 241, 3 factors in 242, and helpfully in 242, the first factor is the factors in 241. You will always do this analysis on my exam. If you are presented with a question in which you are analyzing whether or not there is performance or not, you will always address section 241 and the 5 factors. That's why we spent 2 weeks on it. That's why you had a writing assignment on it. You will do something extremely similar on my exam, and most likely on the bar exam, where you often will see breach questions. And what's helpful about that analysis is it is one of the first factors that goes into the 242 analysis, which says, in determining the time after which a party's uncured material failure to render offer performance discharges the other's duties. Translate, gives the other party the right to cancel the contract and find someone else to do the job. The following circumstances are significant, those stated in 241. And as I mentioned, you have already done that in your analysis. It should be a robust analysis, most likely with an umbrella paragraph where you state the rule, which is that there are in fact 5 factors, and then most likely 5 subsequent paragraphs in each paragraph dealing with how the facts apply to each of those 5 factors, 1, 2, 3, 4, 5, followed by a concluding paragraph. So I would expect to see on average 7 paragraphs dealing with 241, an introductory paragraph, a paragraph about 1, 2, 3, 4, and 5, and a concluding paragraph balancing those 5 factors and concluding on whether or not you have material breach or substantial performance. And then when you begin your 242 analysis, you can begin by saying, as stated above, we have determined that there is most likely a material breach. In fact, this material breach is not just a close issue, but an obvious material breach, and that will be a factor in favor of total breach. What were those factors? Those 5 factors: the extent of the deprivation of benefit of the party that was harmed, the adequacy of compensation for the injury to the party that was harmed, the extent of the forfeiture by the person who committed the breach, the likelihood that the person who committed the breach will cure, and this also follows into whether or not we have total breach, right? If we have a likelihood of cure, and the extent to which there was bad faith or a lack of fair dealing during the course of performance. Right, those are our 5 factors. You'd be very familiar with them by now. Now we add to that, and by the way, these all roll into factor number 1 of total breach. So again, material breach is a factor in total breach. Why? You cannot have total breach without material breach, and a more egregious material breach is going to lead us to find total breach. Now we go on to a few additional factors, and we look at the extent to which it reasonably appears the injured party will be harmed. Right, so this goes to the cure period. Should we have a short or a long cure period? Well, it depends on whether or not waiting will harm you. Yeah, so let me give you the example of the roof that wasn't built. We discussed whether or not a roof that has a small hole in it has been substantially completed, or whether or not a small hole in a new roof is a material breach. Well, the purpose of a roof is what? Keeping out the water. Does a roof with a hole in it keep out the water? It does not, as Mary Beth and I both know firsthand, right? Even a little bit of gap in the flashing, as happened in my instance, right, can result in water intruding into the house. Now, as water intrudes in the house, what happens to my house? Laura, what happens to my house as water intrudes into it? It gets wet. It gets wet. Is that okay? Houses should not be wet. What happens over time, right? The drywall degrades. The floors warp. Mold grows. All of these things will increase the damage to my house over time. It is actually a relatively urgent matter. We had a lot of weather this March, right? And so the hole in my roof, or even the narrow gapping among the flashing, by the way, that's the part of the roof that connects the chimney. There should be something there. In my case, there was not. Even though I have a new roof on my house, the contractor is clearly in breach. However, this particular contractor said, I will get someone out there tomorrow. I will get my best guys on the job. We'll be out there tomorrow. Right? Why is that a factor? Why did he need to say that? Because although he is in breach, he has the opportunity to cure. He has the opportunity to cure until he's in total breach. Now, the time for performance, right? If he says to me, I'll be there in 3 weeks. We had a lot of weather these 3 weeks. What can happen to my home in 3 weeks if I have water intruding the house? The floors can warp, the drywall can degrade, mold can grow. And it's unreasonable for it to take that amount of time to fix a small hole in the roof. So that would go toward total breach in the contract. That would give me the right to cancel that contract. However, he called me and said, I will be there tomorrow. Right? Reasonable likelihood of cure. And our third factor, the extent to which the agreement provides for performance without delay. when material failure to perform or to offer to perform on a stated day does not itself discharge the other party's remaining duties unless the circumstances imply that the performance of the day. If the contract says you're supposed to, if the contract says time is of the essence, then we're going to find time is of the essence in performing. All right, we're going to listen to what the contract said. I will have your roof on your house by March 1st. It is now March 2nd. Are we in breach? We are in breach. Are we in total breach? Well, the contract did state time is of the essence. Time is of the essence in many construction agreements. Maybe there's some other factor coming in, right? And so if we have a clause in the contract that says we have a stated period of time, we're going to usually honor that time. So our 242 factors begin with our 5 factors from 241, and then we add to that the extent to which delay either prevents substitution or I would add causes harm. Right? If I am not unable to get someone to fix my roof because roofing season, right? This is now what we call, we have what, 2 seasons in Pittsburgh? Construction and winter. Fair enough, right? Winter is now ending and now we're beginning construction season. It is hard, I can tell you this firsthand, to hire someone during construction season because they are all working. They have all been dormant over the winter. It's much easier to have someone come out and do your roof for a day on February the 3rd as opposed to May 25th, when they are trying to get all the roofs done in preparation of the winter. So the extent to which delay prevents substitution and the extent to which I am harmed by the delay, that water intruding my house. Think about those drips of water pooling, the extent to which we need to prevent that from causing other damage, and the extent to which time is of the essence in the contract. The concept here again is cure time. Cure time. And for those of you who wear gel nail polish, think about the time you need for that gel nail polish to dry. There is a reasonable period of time you have to wait until that nail polish is cured, right? There is some amount of time, but some circumstances do not permit this amount of cure time. Right? And when the cure time is up, yes, is this a question? Yes.
So for time of the essence, is cure time permitted?
If time is up, so these are all factors. And we're talking about the extent, if the contract says you shall perform by March 1st and it's March 2nd, that is going to be a factor favoring total breach. But it is only a factor. We're going to look at the extent of the breach, the reason for the breach, the existence of good faith, the other factors as well. So yes, absolutely. Say I need a roof by March 1st. The contract says by March 1st. The roof is not installed by March 2nd. Is it total breach? Well, that's certainly a factor. Right, that's our 3rd factor, but it's not the whole thing. Now, when the cure time is up, any remaining material breach becomes total breach. You cured some of the breach, you did not cure other of the breach, right? The time has run. The time when the time has run, whatever that reasonable time is, the time has run, and now the party who is harmed has certain additional rights. They can cancel the contract, they can find substitute performance. However, the contractor calls me up, says, I will fix your roof tomorrow. I immediately call somebody else to come and fix the roof today. And then I call the contractor and say, our contract is canceled, I'm not paying you. What have I just done? I've just breached the agreement with my contractor because the cure time had not run. So it's very important to understand whether or not the other party has the right to cancel the contract. I have the right to withhold payment. I have the right to withhold payment because there's a hole in my roof, but I do not have the right to cancel the contract and find substitute performance unless and until the cure time has run and we are now in total breach. So let's talk about our first case and see how this operates. Anyone with the facts of Sackett v. Spindler and a little bit of help with this case. We're going to, a couple questions here about when breach occurred. There's a timeline to go over. So volunteer for Sackett v. Spindler. Yeah, Kyle.
Here we have the sale of a corporation, or the sale of shares of a corporation from the owner of the majority of shares to another. This owner of the majority of shares was Spindler, he's the defendant, and it's being sold to Sackett, the plaintiff. Spindler was the president of both S&S newspapers, which is
This newspaper.
It's a Santa Clara newspaper. That's important, which Santa Clara's a pretty cool place.
Beautiful place. Beautiful place. Look at those palm trees.
Yeah, so the total purchase price of the shares was $85,000. And Sackett paid, I think, $6,000 on or before July 10th. $20,000 honorable before, or needed to pay this way, $6,000 honor before July 10th, $20,000 honor before July 14th, and $59,000 honor before August 15th.
Now this is a common setup here, right? We're going to have payments over time. We're going to have payments over time. And why can this matter? Does anyone here pay for anything over time? Anything any of you in this room pay for over time? Mark? Your car. Sure. You make those car payments over time, right? Many of us have car payments, right? It's a bit different than a lease where you're not paying for it, but a car that you're financing, you pay for over time. Very similar. Very common arrangement to have payments over time. Now, why is this significant? What can matter what is the difference between paying over time or paying it once?
Well, it determines if your duties discharges someone's breach or if you have to continue the contract.
So what we need to look at is, do these segmented payments mean we have separate contracts, separate conditions precedent that create separate duties, or are these all part and parcel of one whole thing? Are these all part and parcel of one whole thing? Our next case gets into this with more detail, but please note that when you have stage payments, you always need to address whether you have effectively separate conditions, which means you have separate duties, or whether you have one contract better understood as a whole. So it's an easy way to complicate the fact pattern by introducing stage payments. Then you have to ask, is this really about performance in chunks, or is this about overall performance? Now, in the case of a car, Mark, let's say, just for example, you have a common finance package of 5 years, right? 60 months. So each month you would pay how much? 1/60th, right? What is the value to you of 1/60th of a car? Not a whole lot. WHOLE lot, right? Not a whole lot, right? It's not 100% of the car. Which 60th of the car would you like to be driving? It's very hard to drive a 60th of a car. It's very hard to drive anything less than an entire car. So what is that contract really about? That contract is really about a car, right? And if you get 1/60th of the car, it's very hard to get the other 59/60ths from elsewhere. On the other hand, we could have a contract which you could break up into more components. Maybe you have a contract to build a house. A house is made of many things, kind of like a car, but it's a bit different in that you don't necessarily need one part to make the other. A house may have a floor, a roof, walls, tile, etc., etc. Failure to provide, for example, granite countertops may not prevent you from using the house. It may be possible to substitute that performance. So we have to look at the nature of the contract to see, is this something that can be more or less compartmentalized, and therefore can we have more or less of the payments? Do we have to look at them as an aggregate or as stages? Right? And so think about that more in the next case. So Kyle, good point though. It's good to note that we have a stage payment. We have some payments made. We have some payments not made. Let me just run through those facts and get us back to where we were as I detoured us. Right? We have this action for breach of contract against the seller, right, for failure to transfer the shares. So that's interesting. So we actually have breach of contract for failure to transfer the shares. What happened? We have some damage. We'll go back to the conclusion. So we have a promise to convey 6,316 shares. Think about whether or not we can break that apart or not. And we have stage payments, 6,000 on the 10th of July, 20,000 on the 14th of July, 59,000 on the 15th of August, and some interest payments if interest owed if payments are not made in full, right? So we actually do have stage payments, but we need to think about whether or not the contract was really for all 613 and 16 shares, or whether or not this can be effectively broken up. So any thoughts on that? Is this a contract for 613, 16 shares as a whole, or can we break that up into its constituent parts? Justin?
When I read it, I kind of thought it was in full, because it's delivered in full upon the final payment. He wasn't getting shares.
That's right.
After each payment.
That's incredibly important here. When was it delivered? It was delivered in full. Mark, when you made your first, or before you made your first payment on that car, did you get part of the car, all of the car, or none of the car? You got all of the car, right? You got all the. You did not get 1/60th of the car, and as you paid, you received the entire car. On the other hand, when you have a house built, they first build the floors, right? You own that. They then build the walls. A house is more compartmentalized than a car. Yeah. So, and here one thing that is really important, we look at the intention of the parties. What was the intention of the parties? And as Justin points out, the number one factor here, the intention of the parties, is that they were to receive all the shares at the conclusion of all the payments. Right, so that counsels. Now, can anyone make a counter argument? Now, that is the better argument, right? But we always want to look at the counter argument. What is a counter argument that says we can break this apart? John?
Just because there was 6,316 of them, the company was always divisible.
You can sell one share. Right now, it turns out, you haven't learned corporate law, you cannot sell less than one share. So you have a contract to sell one share, and you may pay for it over time. That's the whole thing. Maybe that's a better analogy to Justin's point. But as John pointed out, we could sell some percentage of these shares. We could transfer some percentage of the shares when some money is rendered. We could transfer more shares when more money is rendered, right? And buy the payment, buy the shares over time. Now, that's not how this contract was structured, though. And you may reason that that's the worst of the two ways to think about this. We should think about this as a contract for a whole and not as stages, because the economics are really different. Right? If the economics are such that I can buy 100 shares today, 100 shares tomorrow, 100 shares on Thursday, and eventually get to 6,316 shares, I have an option. I can buy up to a certain number of shares. An option is valuable. Right? An option is valuable because I could buy a few shares, the company goes down, I don't want to buy any more. I don't have to make that full commitment. Right? I can hold that option, and it has value. That doesn't seem to be the intention of the parties, because what did the newspaper want? What was the status of the newspaper, Kyle? How are they doing?
They're not doing well.
They're not doing well.
They're not doing well at all.
And
And
they-
in fact, Spindler it got more difficult to operate the newspaper as time went on. And he had to take out loans, like $4,000 by mortgaging different parts of personal property that he owns. And he sold half of his stock of S&S for 10 grand. And then
like second mortgage his house, and really bad financial states. And you know what? He didn't need $6,000. He needed, what was it? The full amount of $89,000, or however the full amount was. That's what he needed to keep this business running. $6,000 was not going to keep the lights on. So we need to understand this contract as one whole contract, even though it has divisible parts, and we should contrast that with an arrangement that may be more divisible, because the ability of the other to withhold payment or withhold all of the shares depends on whether or not some of that divisibility occurred. Okay, so what then actually happened? How much was actually paid? $6,000 was paid on time. $6,000 was paid on time. So far we're good. So was there a breach at this point? What do we call this? Right now, what state are we in? We have 4 states that the contract parties may be in, each of them separately, right? We have to look at both parties. They have 4 states of being: complete performance, substantial performance, material breach, and total breach. At this point, what state is Sackett in?
he's not in complete, well, it depends on how you look at the payments. He's in complete performance of the first payment.
At this time.
At this time.
At this time, the state of the world is Sackett is in a state of complete performance, because he paid his first payment on time. Okay? And what are the rights of the other party when the other has completely performed? There's no discharge of duties under any state of the world. Whether it's an express condition, whether it's an implied condition, whether they're independent promises, the other person has the total duty to perform. Well, the story doesn't end there, of course, right? We have a lawsuit here. It's not the state of the world. There's complete performance and failure. Melanie?
I just have a question.
Yeah, sure.
So, are we not looking at it as a whole then? Because as a whole, $6,000 isn't that much. Like, isn't the entire contract. So why would it be complete performance? Just because at that time that's all that was due?
At this time, that was all that was due, right? You are not in default. You are, so currently he is fulfilling all of his obligations, right? The question is, what does Sackett have to do to get the shares? He has to pay $6,000 on, I forget the date, was it the 14th of July? He has to pay a certain amount on a certain date, a certain amount on a certain amount on another date,
And then
on the 10th.
$20,000 on the 14th, and then $59,000 on the 15th of August.
At this point in time, he has done everything he is supposed to do under the contract.
So if you meet the deadline properly and on time, you're in complete performance even if the entire thing is not completely
You're in complete performance. There is still more performance that's due, but they're not due yet. Right? Now, there is something that can happen in the meantime. But maybe you're asking them, so why is Professor Ornberg even bringing this up? Right, so what does that matter? Of course he's in complete performance, but he's going to fall off the wagon here. Why does this even matter? Well, we're going to learn about repudiation. At this time, he's completely performed, but he might anticipatorily repudiate on continuing to perform. He might pay the $6,000 saying, by the way, I'm broke. Right? Someone owes you $80,000, and they say to you, I'm broke. Now, we're moving ahead a little bit, but let's use our intuition here. Someone says they're going to pay you $80,000, and they later say, I'm broke. Do you think you're going to get paid? Do you have some reasonable doubt as to the fact that they might complete in the future? Yes, you do. Yes, you do, right? What might you be able to do? You might ask for reasonable assurances, and you may be able to cancel because, for example, let's say you're lending them money on an ongoing basis, or let's say they have a credit line with you because you're a bank, right, that they could draw from. Maybe you can freeze that credit line. They're not in breach yet. They're completely performing, right? On June 1st, I made my payment to American Express. And on June 2nd, I called American Express and said, by the way, I'm broke, right? Now, is American Express going to let me continue using my card to buy a $250,000 Lamborghini? They don't have to necessarily, right? Because I may have anticipatorily repudiated, right? We're going to get to that next chapter, but we're setting that up now. Kyle.
Will that apply in the case when you're buying a $3 coffee instead of a $250,000 Lamborghini? They could still freeze the credit card?
It depends. I mean, broke is broke is broke. If you say if you called up your bank and said, by the way, thanks for the credit line of $100,000, I'm never going to repay you a single cent. Nah, right? They could freeze the credit line, even to the extent of 1 cup of coffee.
Okay.
All right. So Sackett originally pays. At this point, he's in complete performance, but he doesn't stay there. What happens next?
He pays late and $200 less than the payment that he was supposed to be paying. So he was originally supposed to pay $20,000 before July 14th.
Okay.
He ended up paying $19,800 on the 21st of July instead.
Correct. All right, and I'll ask a few questions after that. So, and we have a couple other facts about payment or not. So when July 14th rolls around, right, we have another performance due. We have a payment due. He doesn't pay. Is that a breach?
Yes.
That's a breach, right? It's anything short of complete. What is complete performance? It's paying $20,000 on July 14th. For him to remain in this state of the world called complete performance, he has to pay $20,000, not a penny less, not a day short. Now, we know that the law is not so rigid. 1 penny less, 1 day short. What state might that move him into? When he fails to pay, we know for sure that when he fails to pay, he is no longer in the state of complete performance. What state are we going to put him into now?
Well, until he paid the $19,800, when he pays that, I think that he's in substantial performance. But before then, I still think that he's in material.
You think he was in material breach and then substantial performance? Justin?
I was kind of going to say the same thing. I mean, you can make the argument either way, I guess.
Let's make the argument, Justin. What are the 5 factors we apply to analyze whether or not he substantially performed or materially breached on July 14th? What are the 5 factors? What is the restatement section that calls for the 5 factors?
241.
Section 241 has 5 factors. Let's go through those 5 factors, and we can do them, Kyle and Justin, you can do them together. So what is the first factor?
The extent to which the injured party will be deprived of the benefit he reasonably expected.
Okay, so let's start with that factor. The payment was not made. To what extent is the party deprived of the benefit expected?
Well, he was deprived of the $20,000 he was expected to be paid on time.
He was deprived of the $20,000 he was expected to be paid on time. Right? He did not receive the payment. There is a counter argument here, though, an important counter argument.
That he's paid $6,000 of the $26,000 owed so far.
They have some of the money. They do have some of the money, but we're staging the payments. There's a more fundamental argument. Let's look at the intention of the parties. What is the provision in the contract that leads us to believe he did not expect to be paid in full on time?
Interest?
Interest. What is interest? Interest means that every day you don't pay, you owe a little more. Maybe I don't want you to pay. Has anyone here ever not paid maybe a credit card in full? Your total balance? Sure. Chase, what happened? Did your credit card company call and said, you breached our credit card agreement and we're going to throw the book at you?
No, they taxed me pretty hard.
Yeah, well, they charge you interest, right? Right.
No, I'm using that term.
Yeah, they tax you pretty hard, right? What's your interest rate? 27% or something like that?
Yeah,
I will actually suggest that credit card companies don't want you to pay on time. They want you to pay the interest. Right? That's how they get you. That's how they get you. They want you to pay it back, but they like it when you pay that interest payment. Right? When you don't pay your credit card payment in time, are you in breach? Well, yes, you didn't pay it as full on time, but are you in material breach? Well, it turns out, how does it work with credit card payments, by the way? Do you have to pay anything every month?
Yeah, I think this particular one, you just have to pay a portion of it. You don't
A
have to
minimum.
pay, they want you to pay.
The contract is structured. We have a minimum payment, right? And then we have interest on we could pay the entire amount. We could pay the minimum. Now, if you pay less than the minimum, now you've breached. Now you've breached. But if you've paid somewhere between the minimum and the full balance, you've substantially performed. You haven't completely performed. You didn't pay the whole thing. But you've substantially performed, and let's go to the second factor then. So the interest indicates that the party was not deprived of the benefit because they didn't expect. They didn't necessarily expect to be paid on full and on time. That's what that interest provision did. Interesting, right? You're trying to protect yourself with interest, and now you've given the party a little wiggle room as to breach. So where does our first factor go? Our first factor is going to favor our late payer. It's going to favor Sackett. Let's take a look at our second factor. What's the second factor, Justin?
The extent to which the injured party can be adequately compensated for the part of that benefit of which you will be deprived.
Right, and as I mentioned, sometimes the same facts can be applied to two different factors. So how does the fact of interest payment go to the second factor here?
That factors into the lateness of the payment, so it you kind of assume that.
The interest payment, Kyle, yes, you have a way to rephrase that.
I was gonna say that the interest kind of compensates for the lateness.
That's right. The interest compensates for the lateness. The contract has accounted for this. We're going to learn about this in Chapter 9. We talk about liquidated damages. Sometimes the contract has a provision where you take care of a breach in a particular way. The contract's provision for interest, right, is going to take care of itself. So where does that factor go to? That factor again goes for Sackett. Sackett isn't moving too far from substantial performance just yet, right? These are factors that actually show he has not materially breached. Michael.
Doesn't the idea that if he couldn't pay it, it sounds like he's never going to be able to pay it, adding more money to what he has to pay?
Do we know that at this time? At this time, do we believe there is low likelihood of cure? In fact, we're going to come back to you for number 4, but I want to stay on track with our order of operations. First, Michael, what is the third factor? What is the third factor under Section 241? Anyone have it up hand? They can help Michael with
The
this.
extent to which the party failing to perform or to offer will suffer the forfeiture.
Okay, Michael, talk to me about forfeiture, and then we can talk about fourth factor. Is Sackett going to suffer forfeiture if we declare that he's in breach?
He's losing the ability to get rid of his stocks, right?
So okay. Let's make sure which party do we care about for the third factor? Which party's forfeiture are we concerned with here? The potentially breaching party. Sackett. We care about Sackett here. The third factor is about the potentially breaching party's forfeiture. Is Sackett going to be in a state of forfeiture if we declare that he is in a state of material breach? No. Justin says no. Why not?
Kind of goes back to the interest. We accounted for
The interest is going to make Spindler whole. Now, how do we make Sackett whole? I'll make this simple here. We give him his money back. He's not going to forfeit anything. He paid $6,000. We give him his $6,000 back. We can give it back with interest. There's no risk of forfeiture. It's not like building a house where you've done the work and that work stays with the land. We can give him his money back. We can give him his money back, so he's not going to suffer forfeiture. Now, since he's not going to suffer forfeiture, does the third factor weigh in favor of Sackett or Spindler? It favors Spindler. It favors Spindler because we don't have to worry about causing a forfeiture to Sackett. Yes?
In most cases where you have liquid assets that are being moved around in the contract, is that going to go towards the party that
There's less
go
forfeiture.
against the party that failed to perform?
If the money can be refunded as opposed to an installation that is permanent on the land, you have a lower likelihood of forfeiture.
But, okay, so
Because you can give them their money back. There could be other factors. Maybe there's an opportunity cost. His money was tied up, and so it'd be forfeited. I mean, this is not the case where you spend $100,000 to redo the interior of a restaurant, and if you lose your lease, you can't do anything with those tables and chairs and kitchen equipment. This is $6,000, and we'll just give it back to you. Tyler.
So another way to think about that factor is, can the breaching party be made whole again?
Sure. Yes. Can the breaching party be made whole again? can the breaching party be made whole again? Absolutely, right? By rescission of the contract or some means other than, yes, right? Which are the opposite of forfeiture. Would they be worse off? Are they going to be irreparably worse off? Or can we make them whole again? Justin?
Well, I feel like if you didn't include in the contract anything about forfeiture and the ability to give the money back to the person, if he really needed the money for the newspaper, there's a high probability.
Spindler needed the money. Spindler needed the money. Factor 3 is about Sackett. Right? This is the fundamental thing. Right? Several of you have found confusion about this. Don't continue to make the confusion. Right? The difference is the third factor, we care about forfeiture to the potentially breaching party, which is Sackett. So don't worry about Spindler for number 3. Worry about Sackett. Worry about the potentially breaching party. Now, Michael, let's go back to you for items 4 and 5. What is the fourth element in section 241? Likelihood of cure. Likelihood of cure. At this point, has there been any evidence whatsoever that there will not be cure?
No, I suppose not.
Not at this point. Not at this point. And so who does that factor favor? Sackett. The breach, I know their names are similar, right? It'd be better if they were Sackett and Jehoshaphat, right? Something totally different, right? So here we have the potentially breach. We can call them potentially breaching party. Kyle.
What are some good examples of reasonable assurances?
Why don't we talk about that in a chapter called Reasonable Assurances? Yeah. So we have a chapter on that. All right. 5. Was there any evidence at this point, Michael? Again, kind of like the cure of any evidence of bad faith on the side of Sackett?
I don't think so.
No. Okay. So let's put it together. That's our 5-factor analysis. And anyone want to conclude then on how those factors should come out? Is Sackett in fact in a state of substantial performance or in a state of the world called material breach? Kyle.
Probably substantial performance.
Looks like substantial performance here. All the factors were in favor of Sackett at this point. And then he actually makes a payment. Right? Which shows that he's attempting to cure. And he's only $200 short. That even makes things a little bit better. All right, so the things are on the up and up, but they don't stay on the up and up. What happens next? He signs a check for $59,200 and it bounces. Doesn't clear. He doesn't have the money in his bank account. Now, another payment was due on August 15th, but the check bounced on August 10th. Who thinks this was a breach? Who thinks it's a breach to write a $59,200 check and have no money in your bank account? Let's do the factor, right? Let's take an analysis, right? Now, the question is, a fundamental question is whether or not, I'll come to you in a second, Kyle, do we do this analysis as of August 10th or August 15th? So I want to first talk about that, and then we'll perform the analysis on that date. So I don't know if you want to start with your question, Kyle, or you want to answer that first.
I said he was in breach at that point.
At the point where the check bounced.
Yes.
I think you could do the analysis either way. Right? And I will argue that you could do the analysis either way, but when do we have, by the way, what is the potentially stronger argument? The stronger argument would be that he was in breach when he did not render performance at the time it was due. Otherwise, we're dealing with something a bit anticipatory. We haven't learned about anticipatory, so I want to focus on August 15th as the date when performance was due. That analysis will be even stronger. We might make a couple remarks about August 10th. We don't want to do too many of these analyses because we might not have enough time to write all that out, but we now actually have 2 different periods where breach might have occurred. He has moved in the state of the world from being in the state of complete performance to being in a state of substantial performance. We feel pretty confident about that, having applied the 241 factors. By the way, since he's in a state of substantial performance, why are we not applying the 242 factors? Because, yes? You need material breach for total breach. If we're confident that he is not in material breach, we're not going to explore if he goes to total breach just yet. We're going to keep walking down the line. So let's talk about what happened on August 15th and see if this constitutes a breach. So what is our first factor that we apply?
The extent to which the injured party would be deprived of the benefit which he reasonably expected.
Okay, did that happen? Did he expect payment on August 15th?
Yes, he's.
Yeah, go ahead, Jacob.
I'd say yes. He needed that money because his business was doing poorly. He needed money then.
Now yes, he expected the money. He expected the money then, and moreover, that was the time for final payment.
Right.
The interest was for late in the meantime, but he needed this final payment. So now we have a factor in favor of Spindler. Now, also, we might want to go for all the points. Right? We want to deal with August 10th and August 15th. We don't have a ton of time. Can we also maybe briefly address how August 10th was different than August 15th? What was different between August 10th and August 15th, Jacob?
The time is of the essence in this contract, so,
Was payment due on the 10th?
yes.
Payment was due on the 15th. Sorry, I'm going a little fast here. Payment was due on the 15th, so on August 10th, factor 1 is not as strong. So we could say something to the effect of, well, factor 1 is clearly going to go toward Spindler on August 15th because he expected full payment at that time, and he received at this point $6,000, or sorry, he received at this point $26,000. He expected to receive more like $90-some thousand, so he needs that money. Now, on the other hand, if we look at August 10th, her payment was not due at that point. Right, we might look at that, and again, this would be a great case to go back to look at anticipatory repudiation, because when the check bounces before it's due, it might show he won't have money when it is.
So is that similar to calling your credit line and saying you don't, you're broke?
Right.
It's when the check
When you
bounces-
bounce a check, that is basically like saying, I don't have money. Right, so August 10th is more about anticipatory repudiation because payment was not yet due. But you see how the first factor counsels differently? Right, the first factor is whether the person was deprived of the benefit. Right, on August 10th, he was not deprived of the benefit because he didn't expect it yet. The payment was not due for 5 more days. So on August 10th, the factor goes in favor of Spindler. Sorry, the factor goes in favor of Sackett. By August 15th, that changes because the payment was due. On the other hand, we'll get to this next week when we talk about repudiation. The fact that the check bounced gave Spindler reason to doubt that the payment would ever be made. Michael.
What about the outstanding $200? Because while that's a small amount of money, we're coming up on the third payment period, and the second payment hasn't actually been fully issued.
Any responses to that before I respond? Thoughts on the $200? Kelsey.
I mean, wouldn't that go back to why he has like the 6% interest?
I think the interest is, we can run the analysis on the $200, but I think when we do that, we're going to end up in a very similar place. Although the payment was due, the interest payment shows that a small amount being unpaid would be covered by the interest. Right? And I think the interest helps us here. Sir?
Was he compensating for it in the last payment?
No, that's, I think at this point they're sort of waiving he was more, the 6% interest over this time would not have added up to a lot of dollars. We have a lot bigger numbers. I don't think he was accounting for the interest in this. But that would be a smaller issue. I think what would have happened is that after it was all done, you could sue for breach of failure to pay interest. And there could be some dispute about whether the interest was due. But we're going to keep our eyes on the big number, that big $60,000 number, or almost $60,000 number. Okay, let's look at the second factor then. What about our second factor?
The extent to which the injured party can be adequately compensated for the part of that benefit of which he will be deprived.
Okay, how does that play out here?
Well, here, the injured party could be adequately compensated if, on the 15th, if he had paid the full $60,000.
Mm-hmm.
But it doesn't look like Sackett would pay that.
Okay,
That
that's a different factor. Again, this is an exercise in being incredibly clear about which facts go to which analysis, right? I talked to you about some of the smushing. We are unsmushing this to the max, right? Mostly for illustrative purposes, right? We want to make sure we have the facts that go directly to the sub-issue we're dealing with. And here, the fact is still interest. He is not harmed to the full extent. He was deprived of the benefit because he did not get the big chunk of change. But can he be made whole? Yes, because the 6% interest payment is designed to do exactly that. John?
How does the 454 shares that he went to purchase play into that? Was he significantly damaged by that, right? Because when you look at how the deal is structured, he probably got that money up front so that he can secure the minority shares then to complete the entire deal. So he's expecting to get whatever the 454 shares worth
Right.
of the stock is going to cost.
So I think John's point here is that there are other factors, and failing to consummate the deal on the date specified could make it hard for him to get additional financing, and that could show the interest was insufficient. I don't think there were enough of those facts developed, and I think to be honest, it's a more advanced finance concept to think about how failure to consummate one transaction can result in others not participating and what have you. It does happen in venture capital, right, where you have a lead investor and the fact that they don't show up on day of signing or they want some extra form, and then 6 other investors drop off, and now you can't get from them. Even interest payments may not make whole because you've lost this team of investment. But we're going to use the simpler version here just for the purpose of getting through our factors. And here, the interest payments are designed to make up for the delay in time. The interest payments are designed, so we have that. By the way, this is the 3rd time we've used that same fact. Right? Those interest payments continue coming up in factor 2 because they're designed to make the party whole. How about forfeiture? Same issue with forfeiture. Minimal forfeiture because, once again, you can get him to give the money back. That hasn't changed. Right? So we have minimal forfeiture, so we're going to be more comfortable with declaring a breach. Now, Michael, now do we have a high or a low likelihood of cure?
I would say it's gotten lower.
It's gotten lower, right? This man has no money in his bank account. How are you going to pay with no money? Not going to happen. Where's he going to get $6,000 for? The guy has nothing in his bank account. He's got, empty pockets. All right, so we have a much different analysis on factor 4. How about factor 5? Bouncing a check. Do you think that Sackett should have known that he did not have money in his account to cover it, Ellie?
I think that's too big of an amount to say you have in your bank account if you know.
You might want to check you might have called, hey, by the way, do I have enough to cover this giant check that I'm writing before I write it? So what might that go to? That might show bad faith. Bad faith. So the factors seem to have changed. Are we comfortable now saying that on August 15th, we've now moved to a state of material breach? I think so. I think these factors look like material breach. So what's our next question? Now that we're in material breach, right? Who's suing whom? Right? Sackett is actually suing Spindler for failure to consummate the transaction. Meaning, the question is whether Spindler had the right to cancel the contract. When does a party have the right to cancel the contract? In material breach?
No, total breach.
No, total breach. Total breach. We know that's the issue. So let's take a look at whether or not there was a total breach here. What are the factors for total breach?
The stated factors in 241, the extent to which it reasonably appears to the injured party that delay may prevent or hinder him in making reasonable substitute arrangements, and the extent to which the agreement provides for performance without delay, but a material failure to perform or to offer to perform on a stated date does not of itself discharge the other party's remaining duties, unless the circumstance, including the language of the agreement, indicate that performance or offer performed by that day is important.
Section 242. 3 factors in 242, exactly. So let's talk about them a little bit. Now, first off, what date matters? What is now the date in question? Are we still at August 15th, or do we want to look at a future date? When does the party attempt to cancel the contract? In fact, when does the party say, I'm canceling? Because that's the day on which we have to have total breach. We don't need total breach on August 18th. That doesn't matter. That doesn't matter under these facts. We care about if there is total breach when the person tried to cancel the contract. Why do we care about that? Because if I try to cancel a contract and you're only in material breach, I have now breached. The question is whether Spindler breached. Whether Spindler breached depends on whether Sackett was in total breach or in material breach as of the day he tried to cancel. What day was that?
October 5th.
October 5th. What was it like for, what were these factors like on October 5th?
Well, we're still in material breach, so those stated in 241, that factor would go towards Spindler.
Okay, and have those factors gotten better? Have any of those, I guess now we can kind of do maybe a simpler analysis. We could say we've already decided there's material breach on August 15th. Now that we're at October 5th, have those factors become more in favor or less in favor of Spindler or of Sackett, right? So we can kind of quickly look through, right? Was there more or less deprivation of benefit? More, right? As the time went on, not having that cash hurt him more and more and more. He lacked operating capital, had to go down to a once-a-week operating schedule. The interest payments were still there. So the interest payments, that's neutral. Number 2 is the same. Factor number 3, forfeiture. We can still give the money back. 3 hasn't changed. 4, likelihood of cure. Has become more or less likely that there's going to be a cure as time goes on and there's no cure. Yeah.
Less likely because he extended the date twice.
Yeah, well, now he did do something. Okay, yes, he didn't pay. But what did he do? Talk is cheap, but He said he was going to pay. He said he was going to pay, right, Justin? He said he was going to pay, and so we have to at least account for the fact that he said he was going to pay, although as time goes on and he didn't pay, right, we have to look at actions and words. And what do they say? Actions speak louder than words. Right? We probably learned that in 3rd grade, or earlier. So what are the actions saying here? The actions are saying there's a low likelihood of payment. Right? His conduct, so does a tendency to bounce checks, ignore deadlines, pay lip service. And all this also goes to an aggravation of the factor of bad faith. So to the extent he was breaching before, it's worse now. Now, what are the other 2 factors?
The extent to which it reasonably appears to the injured party that a delay may prevent or hinder him making reasonable substitute arrangements.
Is Spindler being harmed as his company goes bankrupt?
Yes, he's taking mortgages on personal property of $4,000. He had to sell half of his stock to an S&S newspaper for $10,000.
All evidence of harm, right? Think about it for yourselves here. Who wants to invest in a strong, positive business with good trajectory and lots of capital? Who wants to invest in a failing business nearing bankruptcy? Okay, so if you're going to invest in a bankrupt business or a near bankrupt business, you're going to charge more interest. His access to capital has been harmed by the fact that this has been going on. And what's our final factor?
The extent to which the agreement provides for performance without delay, but a material failure to perform or to offer...
Was time of the essence. The short version. Short version was time of the essence.
Yes.
Yes, we had timelines in this, and they were not performed. So what does this look like, Kyle? Do you think we're now in total breach? On October 10th, was there a total breach? It looks like we're in total breach. It looks like now we get to total breach. And what does that mean? That means that the October 5th letter was not unlawful. Because total breach by you gives me the right to cancel the contract. Right? And so when we get here on October the 5th, there was not an unlawful repudiation. Right? Moreover, Sackett disregarded it, etc., etc. That is how you apply the 5 factors in 241 and the 3 factors in 242 to determine whether or not another party has the right to cancel a contract. If they don't have the right to cancel, in that case we have a breach by the other party. Now the court uses some terms that I don't particularly agree with. It says that Spindler rescinded the contract. Right? He rescinded the contract when he reclaimed the stock certificates from the lawyer in mid-September. There were some stock certificates in escrow. Now, was that a rescission of the contract, or do we have a better terminology for what he did there? He did it lawfully. So what are you allowed to do when the counterparty is in material breach? Suspend performance. Right? He suspended performance. He said, you can't have those shares. They're going to stay in escrow. I'm not saying you can never have them, but you can't have them now because you haven't currently paid for them. So that was an example of suspending withholding performance. And they say he repudiated the contract on October 5th. What is a better way to phrase that? What did he do on October 5th? Canceled. We're going to use the term cancel. Right? He withheld performance. He lawfully withheld when the party was in material breach. He then lawfully canceled when the party was in total breach. Right? Okay. All right. One more case for this subject, and then we'll move on to repudiation itself and talk about anticipatory repudiation. So what happened? And Justin, can I go back to you here for this one? Your chance to.
Actually, no.
Any of your Patrick, have you had a chance to read this case?
I just read the first one as well.
Lee? Okay.
So, I did.
3rd time's the charm.
So it's an action between a contractor and a subcontractor. And on page 927 in the middle paragraph, the question is whether a contractor damaged by a subcontractor's failure to perform in a workmanlike manner have a right to withhold a partial satisfaction of such damages in installment payment.
Excellent. That's the question presented by the court. That is our main issue here. Our main issue is whether a contractor who is damaged by a subcontractor has a right to withhold payment. A right to withhold payment. And moreover, we have installment payments, right? We have payments over time. So I have here the timeline for you as we are getting close to the end of our time today. So we'll kind of start with that. So the issue here really is whether or not the contract was whole or in installments. Because as we'll see, the contractor, the general, withheld payment of the whole, And so now we're getting back to that issue of whether or not it was proper to withhold all or some. While I have these on the board here, Lee, can you just kind of walk us through, and you can use this to help you through this, but our general timeline of events involving an unfortunate bulldozer incident.
So in July of 1958, the subcontractor performed the work, and he performed the work as required under Section 3A of the contract until September 2015. But the subcontractor, according to the fact, the subcontractor invoices for work done, and the payment was due August 10th, and then on August 9th, there was a bulldozer accident.
Oops.
And then the contractor refused to pay subcontractor's requisition due on August 10th because of the bulldozer demolition.
So the August 10th payment that was not paid, what was that money for? What was that money for, Tarina? For the month before, 30 days prior. So, did that include the time period in which there was the unfortunate story of the bulldozer and the wall? No, these, you're right, you're right the first time, right? That payment, that first payment, was for prior to the incident happening. Right? And so, what is the contractor doing? He's withholding payments that were due for a period of time during which, what was the state of the contractor? Right? We have 4 states. Was the contractor at that time in a state, as we know, of complete performance, or at least substantial performance? Yes, 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 as to that installment. As to that installment. So the question here is whether or not it was wrongful to withhold payments on an installment. Effectively, what is the contractor doing? They're treating the contract as a whole. Yeah? They're effectively treating the contract as a whole. And so the question really is not so much about breach or not breach, because what does the court say, Lee, about breaching a contract by driving your bulldozer into a wall? Does the court do the 5-factor analysis? What is your intuition? Let's just do it. I mean, this is not just do it on an example. What is your intuition? If your job is to build a wall, and instead you drive a bulldozer through it, have you breached your agreement to build a wall? Probably. Probably. That's probably not going to rise to the level of substantial performance. Now, I will point out that this court, as many courts do, did not perform the analysis correctly. They did not go through all the factors. They did not apply the test. They did not do this rigorously. Perhaps because they did not find this to be the issue. Perhaps because the parties were not really disputing it. If you drive your bulldozer through someone else's wall while you are supposed to be improving their property and not causing it to crumble to the ground, you have probably breached that contract. Yeah, and so here we can use a little bit of intuition to get us where we need to go, although I will point out we could apply the 5 factors. The court does not. This determination was based on something else. And I think I saw a hand, a page that, no, just a thinking critically hand. So the court does say something about whether or not there was material breach here, right? And it's not the 5 factors, but just for our reference, what did the court say as determining why this was important? Yeah, Tyler.
Say that Section 8 was that all work should be performed in a workmanlike manner.
That's the provision that you're right. I should have done that also, to always pull out the contract provision at issue. But what is the court's reasoning to say that that provision was breached?
Well, they're pretty clear that knocking down the wall was a breach and not very workmanlike.
It was definitely not, but the court does say a little bit more, right? The court basically says that the accident was material because the damage cost twice the amount of the payments. And so it's sort of used to say, well, it's obviously material. And again, this does seem a bit obvious. It does seem a bit obvious, but I want to point out that one reason that we are looking at this case so critically is the court did something that you should not do. Right? The court took something as obvious and treated it as obvious. You're going to treat something as obvious and treat it as non-obvious. Right? That is part of the law school game. Right? The part of the game is you do not treat it as obvious. You treat it as an opportunity to analyze the factors at issue. You treat it as an opportunity to show the examiners that you know the rule of law. You treat it as an opportunity that you can show Professor Orenberg that you can apply the 5 factors in 241 to a situation, even one so obvious as driving your bulldozer through a wall. Right? We are still going to perform the rigorous analysis each and every time. The court failed to do that here, and in fact, exposes itself to reversal on that issue. as a matter of law. Why? Because the court applied the wrong law. An appellate court could reverse this decision. Judges hate to be reversed. It is bad for a judge to be reversed. It's embarrassing. It can lead to a lack of opportunity to move up, to become a chief judge, what have you. Right? And you expose yourself to reversal when you don't do the analysis. And so the analysis should always be performed rigorously, even when things are obvious. Ignore the motion over here and enjoy lawyers on location. Excellent program that we have, by the way. So glad for all of you who are shuffling out to participate in that. Right? And fortunately, you've heard the main of the lecture for today, right? The point of the lecture for today was understanding 241 and 242, and actually this court doesn't get it right. This is a much smaller case. This case has to deal with whether or not the payment should be treated as a whole, or whether they should be treated as piecemeal. And Lee, what does the court say about that?
If the subcontractor breached the whole contract on the August 9th contract, it is suspend performance.
That's right. If they breach the whole contract, then you could suspend performance, meaning you don't have to pay. But if they only breached as to an installment, you have to pay the installment during which they were not in breach. So, was this contract better understood as a whole, or is it better understood as compartmentalized? What does the court say about this? Yeah, Jacob.
It says the subcontractor's promise was by the explicit wording of the contract precedent proceeding to the promise of the payment monthly by the contractor.
By the payment monthly, meaning we actually have separate contracts here, and the court says that there is a presumption. We have a couple of presumptions here, right? We actually have, is this my, did I go too far here? Okay, no, I have that in the next slide. We have two important presumptions here. So this case is not useless, even though the court did the analysis badly, but you know better now. You've done a better job yourselves on Wednesday, right? When you did the learning module. You did a better job than the court did here by rigorously applying the 5 factors and now the additional 3 factors. But the case is useful. What does it say about whether we should understand these sort of contracts to be independent promises or dependent conditions? It says that we should understand, and by the way, what is the section of the restatement that this goes to? Section 266. Section 266 of the Restatement Section of Contracts accords with the court and says that there is a presumption that mutual promises are dependent. I tend to take this view. I tend to take this view because when you think about consideration, you're getting something for what you're giving, you're getting something for what you're getting, you want what you're getting, you want what you're giving to be in exchange. And so this presumption of bargain for exchange, the presumption of consideration, tends to lead us to the presumption of dependent conditions. Amanda.
Why did the court favor making this a promise instead of a condition?
So I think the court actually favors making this a condition. I think what the court's saying here is it's according with Section 266 of the restatement. Why? Now, this is an important policy decision, though. And by the way, for further consideration, look at Section 266. Look at the illustrations and the comments there. Why would we presume that my payment to you is conditional on your work for me? Or on the alternative, why should we presume those are independent? Courts used to presume that promises were independent. Courts now presume promises are dependent. That's sort of our default position. Why might that be? Now, there actually is reasonable debate about this. I'm going to make it easy for you and tell you that I'm using a Restatement 266 jurisdiction in terms of what rules I ask you to apply, but it accords with my thinking. My explanation for this is that I have explained to you consideration is not a benefit or a detriment. It is a bargain for exchange. I want this from you, and you're going to give this to me. The reason I'm doing this for you is because of what I'm getting in return. The reason I'm going to work on your house is because I'm getting paid. The reason I'm paying you is I'm getting the work on the house. The presumption should, in fact, be that these things are dependent on each other in these type of contract or arrangements. Now, not every promise works like this. Not every promise works like this. But mutual promises in a contract are dependent and are sort of regarded wherever possible. That's the presumption from this court, and it accords with Section 266. And I think it also accords with the understanding of consideration as a bargain for exchange. The assumption is that parties intend performance of one to be conditioned on performance by the other. I expect that I will pay you when you do the work for me. That's my understanding. That's the default presumption. right? And you're not expecting to be paid whether or not you do the work, and then I can sue you. I think there's another reason why this is the better rule. Fewer things go to court. You don't perform, I don't pay you and sue. By having independent promises, that was my recourse. I breach and you breach and we sue each other. How about you don't do the job, you don't get paid? That seems to me the more normal course. Now, the presumption doesn't always make sense. I think it makes sense here. We have a subcontractor who has a duty to perform something in terms of progress payments. In order to get your progress payments, you have to perform what was asked of you under that payment. But I think that there are other types of promises, but you take as a baseline presumption that promises are dependent. They're conditioned on each other. Sir, Robert.
So how are we gonna apply this Restatement 266, for example, next time? Should we just state the presumption is that we have mutually dependent promises and conditions, and only examine whether there's maybe another type of covenant if there's clear circumstances or evidences that indicate it?
That's the rule. Look at 266, and exactly right. You begin with the presumption that, especially in a situation where a contractor will do work and get paid, the presumption is that the work is a dependent condition of the payment. That is your baseline. And then you would need to find evidence to the contrary, as opposed to starting for the presumption that the promises are independent and finding evidence to the contrary. It's just a question of where you're starting from, right? And when do you do that in the analysis? How do you go through this analysis? Well, you first say, what does the contract say? What are the terms? What do the terms mean? What terms are added because of parole evidence? What terms are corollary and so are added even though they are excluded by parole evidence? And then, are those terms promises or conditions? At the time when evaluating whether a term is a promise or a condition, the baseline rule is that generally they're dependent conditions. And then you would need evidence to the contrary. And this is the case you cite to that, and Restatement 266 is where you cite to that. And Restatement 266 has, I believe, 13 examples on this. It's all available to you on Westlaw. I'm also, by the way, working on making the restatement a little more user-friendly for the class, and so we'll have that for you as well, so you can access that a little bit more easily. But for now, you can all go into Westlaw at any time. You all have your accounts. You can read the restatement. You can read the illustrations. You can read the reasoning. You can read the comments, and they are all there. In addition, we have a presumption that contracts are indivisible. So Lee left for Lear's on location, but the presumption here is that when the total price for work is fixed by a contract, the work is not rendered divisible solely by payments. Right? And think about Mark's car. He's paying for it in stages. Doesn't mean he wants 1/60th of a car, then 2/60th of a car. No, he's getting the whole car. Right? And they want the whole money. They don't want 2/60ths of the money either. The presumption is that a contract is for a whole, even if it is staged. Right, and that also goes back to our case, right, Kyle? What was at issue here? We're selling 603,016 shares of stock. The presumption is that it is for the entire amount, right? Even if you pay in stages. The reason for progress payments is usually for convenience, not because we actually see the work as divisible. Now, of course, like I said, these are baseline presumptions. This is where we start the analysis. And if you say, I will pay you $2,000 when you complete the floor, and $3,000 when you build or for that matter, I will pay you $2,000 when you put the roof on my house, and $1,000 when you put a new roof on my freestanding garage. Okay? Can you see how that's different? I could have said, I will pay you $1,000 when you've completed 1 month of work, $2,000 at 2 months of work, whatever, right? On one project. But if I'm going to pay you $1,000 when you do one roof and $2,000 when you do another roof, those do seem independent, not part and parcel of another. But this case also says that the presumption is the contracts are indivisible. So as a result of the contracts being indivisible, was there a breach? Yes, there was a breach. Was it a total breach? It became a total breach when the contractor said, I'm not paying, right? Neener, chase down the insurance company if you want, but I'm not paying for that wall. That's a total breach, right? Again, the court did not do the analysis as thoroughly as you should, and as we just did several times here. But fundamentally, that was a total breach. And was the refusal to pay acceptable? Yes, it was, because it was a refusal to pay on the entire contract, which is presumed indivisible.